So this video is going to take you through how you're going to go about stating, explaining, applying to a theft scenario. So remember, theft is a statutory offence. So the main thing that we're going to do is go through the sections of the statute and say how you can see them in this scenario. So the scenario we're going to look at, starting with the question, is to advise Eddie whether he would be found liable for the theft of the wallet. So Eddie attended a football match. Dan, one of the rival supporters, was running down some steps during the halftime interval. Eddie pushes him. Dan falls heavily on one of the steps and he's knocked unconscious. Eddie, pretending to help, took Dan's wallet from his coat, intending to keep it. However, when a stadium official came to help Dan, Eddie put the wallet back. So we're just going to focus on the theft. If you're thinking, isn't there a robbery there? There was an element of force or a threat of force. You're absolutely right. But we're just going to focus on the theft first of all. So we're going to start by defining theft under Section 1.1 of the Theft Act 1968. Section numbers are key where it's a statutory offence. So guilty of theft if they dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it. And it's nice to mention it's triable either way, with a maximum penalty at the Crown Court of 7 years or an unlimited fine. So we start with our actus reus elements. So appropriation, and we can state that it's the assumption of the rights of the owner, including a later assumption of rights of the owner by not returning something to its rightful owner. This includes everything you could do with your own property: selling, keeping, destroying, etc. And this is seen in the case of Lawrence, where the student offered the taxi driver her purse so that the taxi driver could take his rightful fee, but the taxi driver took far more. It didn't matter that the student had offered it up. And the appropriation takes place where Eddie took Dan's wallet. Moving on to property, this is nice and simple, but you do have to state that it includes money, all other property, real or personal things, including things in action, and can be intangible property. What isn't property is land, wild things like fruit, mushrooms, flowers, foliage, and wild animals that have not been tamed. You can explain this with the case of Oxford and Moss, which held that the information on the exam paper couldn't be stolen. And in this case, with Eddie and Dan, the property is the wallet. So belonging to another, Section 5, property is regarded as belonging to another person having possession or control or any proprietary right. That means that you can steal your own property. So if you've received property under a certain obligation, then you have to deal with it in that way. Property received by mistake, there's a legal obligation to restore it to the rightful owner. This is seen in the case of Turner number 2, where our defendant stole back his own car from the car garage without paying for the work that had been done. And clearly, the wallet belongs to Dan, not to Eddie. So moving on to the mens rea, there's more to say here, there's more application to do. So Section 2, dishonesty. You first of all have to say what the statute says somebody isn't dishonest. So if they believe that they have a right in law, that the owner would consent, that the owner cannot be discovered by taking reasonable steps. And we can apply by saying none of these apply to our defendant. We then have to explain what dishonesty is by using the Gauche test. We know that there's a two-part subjective and objective test. And we know that the case of Ivy and Genting 2017 removes the subjective element. So it purely is, when we look to apply, does the reasonable man think that their conduct would be dishonest? And we can apply by saying, yeah, the reasonable man would consider Eddie's conduct to be dishonest. And finally, intention to permanently deprive. So this is to treat the thing as your own or to dispose of it regardless of the other's rights. This is seen in the case of Velmill, where our defendant took cash from the safe and he intended to permanently deprive by not returning the exact cash that he took, put back different notes. In this case, we can apply by saying Eddie intended to keep the wallet and he only put it back for fear of being caught. And we can overall conclude, therefore, that Eddie will be likely to be held liable for the theft, even though he didn't eventually keep it. So that's how you go about stating, explaining, applying the law of theft to a scenario question.